Welcome to Family Law A to Z with DBD.
Welcome to Family Law A to Z with DBD, a podcast from the Pennsylvania-based firm Dischell, Bartle, Dooley. This series reflects the collective experience of the firm's family law team, including attorneys Mark Dischell, Elizabeth Billies, and Katie Lynn Daly, who work together closely to provide clear, practical guidance on the legal issues that impact your family and your future. I'm LeAnn Lyon, and today we are talking about mediation in Pennsylvania family law cases and how the process can help families work through disputes outside of traditional litigation. Joining me for this conversation is Elizabeth Liz Billies, a partner at Dischell, Bartle, Dooley. Liz practices all areas of family law and is known for her thoughtful, collaborative approach to divorce, custody, and support matters. She focuses on helping families navigate transitions effectively and efficiently while keeping long-term stability in mind. Hello, Liz.
Hi, thank you so much for having me.
What does mediation look like in Pennsylvania family law cases?
Sure. So just to set the scene, I am a certified mediator. I went through a specific training with a specific number of hours. So this is something as an additional certification on top of my law degree. So if you're going to mediate a case, and we'll talk about that a little bit more later, what to look for, you want to make sure you're working with a certified mediator. So mediation is a process outside of the court system to resolve some portions of your family law case. So it could just be custodies only, or your divorce, equitable distribution, your economic claims only, or you can mediate everything. A lot of parties will do it after a divorce complaint has been filed, but they also will do it after they just have separated. No one's seen lawyers and no one is filed anything, but they know that they want to go through the mediation process instead of going through the traditional litigation route. So mediation itself is where the parties ultimately come to agreements on how they want their divorce or their separation to go. And again, it would be in terms of custody of the children, possible support payments for the spouse or for the children, and any other economic claims related to their property. So those are done with, it can be done with or without attorneys, and we'll talk about that as well later. But also it can be, it's not with a judge. You're not going to court. You're not doing it in the court system. You're doing it in a private setting. So it has to be, it's by choice. And it's not, in general, it's not going to be, and particularly in Pennsylvania, it's not going to be court ordered.
So I know you've already mentioned a couple of situations where mediation might be used. What do you think that your let's say top 5 types of family law issues that are commonly addressed through mediation?
Sure. So custody, I think, is probably number one. And I think custody is probably best mediated, because at the end of the day, they're your children, and you and your co-parent should be making those decisions regarding your children. The way that the court system is set up is, and no shade to the court, to the judges and the court personnel out there, but they just don't know. They're never going to know your kids like you guys, that you and your co-parent are. And so mediating your custody issues, what the schedule is going to be, holidays, regular physical custody schedule, how we're going to make decisions for the children going forward, how we're going to communicate going forward. All of those things, I think, are perfect for mediation. You obviously both need to be willing to talk to each other and resolve the claim, and work on those claims together with the mediator. But that would be my number one. Number two, I would say, would be the dividing up of the stuff, and that is equitable distribution. That's the term here in Pennsylvania, but I like to explain it to my clients as we're dividing up of the stuff. And when I say your stuff, I mean your major items, your houses, your retirement plans, your bank accounts, things like that. that I also see a lot of people want to mediate. A huge incentive there is, besides, having the power of the decision making, it's saving money. And it's fast. It's generally is faster than the equitable distribution process in most counties in Pennsylvania. So those would be my top two. The third one that a lot of people mediate, I don't see it as much as compared to those two. But the third one that I see is also personal property. So when I say personal property, that is the little stuff, right? That's, who's going to keep the couches and maybe the Peloton bike and the art on the wall, those kinds of things. A lot of people go to mediation to resolve those kinds of things, because again, it's really not worth the legal fees to hire attorneys to do that. The court system doesn't really, it's just not good for the court system. They don't handle those claims very well. You're waiting a long time. So those things I see people mediate a lot. Not as much as the other two, but I would say that would be a third, because and also at the point where you're dividing up those items, it's usually you're really tired of the lawyers, you're really tired of the court system. So you want to just meet with a mediator, maybe 1 hour, get this resolved and move on. So that would be the third. Those are probably the top three that I see for mediation in the family law context.
Perfect. Well, you kind of touched on this as well, but it works well when people are communicating, but some people assume that mediation only works when parties already agree on everything. So what does the process look like when there are still meaningful disagreements?
Sure. So it's funny, when I did my training to become a certified mediator, that was what I thought about mediation, frankly. It was like, well, if it doesn't end up in a final full resolution, this mediation has failed. And my trainer and I've come in my own work to see, like, that's simply not true. If you can resolve portions of a case, I'll give you an example. So let's say we're mediating a custody case. We might be able to resolve the holiday schedule, the vacation schedule, decision making, shared legal custody type items. Those kinds of things maybe we can resolve all of those things. Maybe we can resolve a good portion of the regular physical custody schedule, but we can't just get maybe that last, who's going to have the child on Thursday overnights, it's just, as an example, maybe we can't resolve that. That doesn't mean we haven't made progress and that it hasn't been effective. You have resolved 80% of your case. And so that is going to get you a lot farther. You're a lot farther than you were when you stepped in the door, right? And so if that's, if you at least resolve part of it, you have made progress. You have saved yourself money, you have saved yourself time, and you've saved yourself, most importantly, probably the stress. So that happens a lot, where people will, then ultimately have to go into the court system to resolve maybe that final push. Though I do find that when people are so close to a resolution and they're just like, a little bit apart, and they see all that momentum of agreeing, it also will help them get to that, get them over the finish line on that last issue. But again, the mediation still has been successful, in my opinion, if it has not. In the money side, even if you just can mediate, maybe we're going to list the house for sale. Who's going to be the realtor? What's the listing price? Like all those little, sometimes what people will call ticky-tacky stuff that you're paying your lawyers to discuss. If you can resolve that in a mediation, that may be putting you, again, you're 10 steps ahead from where you were. That could be considered a successful mediation, even if you can't agree on how the assets should be divided, who should get what. So there's always success in a mediation, even if it's not, as long as there was, some agreements, there has been success. I know parties want to get everything done, and I appreciate that, but I try during my sessions to really explain to them, like, hey, you're making progress, you're saving yourself money. Like, think about, you're in the driver's seat making decisions. And that also can feel like success too, that like we owned our own divorce. No one else told us how things should be done. We decided. And so even if it's not 100%, there's still success there. And so I try to remind the parties of that. And again, I think sometimes when you have that momentum of agreeing, it can really take you far into resolving the rest of the case too.
So what factors usually help determine whether mediation is a good fit for a particular family law matter?
Sure. So, first thing that I am required to do is to do a domestic violence check. So, if there is a concern regarding domestic violence between the parties, I cannot mediate that case. And so that is something that right out the gate, that's going to be a no for mediation. No one should ever feel unsafe and be put in a position to feel unsafe. That is, as a mediator, my ethical duty is to not take that mediation on because of that risk. So that would be one, just a real easy one, like can't mediate that one. I think every case can be mediated. The hardest ones to mediate are really when there is a legal issue that is in dispute. Doesn't mean you actually still can't resolve it, but if it's a legal issue that's like a really big, tough one, that is not necessarily going to be something that can be successful in mediation because the parties are not lawyers. And I can't give legal advice as the mediator. So I can't say yes or no, someone's right or wrong. I'm not the decision maker. I'm helping the parties come to a decision as the mediator. I'm facilitating a decision, but I'm not the decision maker. And so if there's a legal issue in either a custody case, or more, there's more happens, frankly, in the divorce, the equitable distribution cases, that probably I would suggest to the parties, hey, maybe get that legal issue resolved first and then come see me to mediate once that's sort of been decided. So that one, those generally are not going to be good for mediation. Another one that I have reservations about mediating is when I feel that one or both of the parties is not disclosing all of the information that is needed to have a meaningful mediation. Again, that's going to more come in the numbers cases, in the equitable distribution, the support cases. But if I feel that someone is not producing all of the documents or the other side has alleged that, I don't think I don't know about all the bank accounts. I haven't seen a tax return in 5 years. That's a case where, because we need to have full disclosure to ultimately have a final agreement be valid, if I have a concern or the other side, one of the parties has raised a concern about not having all of the information, I'm going to want to help them get all the information. That's something I can help with in mediation, is to help them make lists of what they need, agree to deadlines to exchange those documents. But if there's still a concern that a party is not being forthcoming, probably going to need to go through the court system to work out those document issues, and mediation is just not the place for that.
So you are an attorney and
Yes.
you're a mediator.
Today. I'm kidding.
And you're a mediator. So what role do attorneys typically play during the mediation process? Is there a real division there?
Yeah. So people's approach to working with counsel during mediation can vary, but this is kind of what I see. So a lot of people want to come to the mediation process. I mean, the two reasons people come to mediation are save money and not involve lawyers. Again, maybe there's three. So save money, not involve lawyers, and get this done quicker and with less strife. All good reasons to mediate a case. So a lot of the parties that I work with are not represented by counsel on either side. However, I find that attorneys can be helpful to be working with someone while they are in mediation. They walk alongside the client. They don't necessarily come to the mediation session. And generally, if there's not going to be two lawyers, the attorneys would not come to the mediation session, but they are reviewing the mediation session notes. They're reviewing the to-do list that I give the client. They're giving the client legal advice on the side. Because again, I cannot give legal advice. I can tell the clients what the law says. I can offer suggestions for solutions, but I cannot give legal advice. It's just, again, it would be against the mediation code of ethics. So attorneys can be really helpful to set expectations for their client, to give them insight into perhaps things to ask for in the mediation, to run support calculations for them, to give them ideas of what a split of the assets would look like, a division of the assets based on certain percentages to each side. So they can be really helpful to help the client on the side. Sometimes I've had parties where one has an attorney working with them during the mediation, the other side does not. And then where an attorney could be particularly helpful is really at the end. So again, once the parties come to, let's say they resolve everything, I would generally do a memorandum of understanding saying this is what everybody has agreed to. And I'm doing those kinds of memorandums. If we have multiple sessions, I'm doing them after each session. But ultimately, the goal is to come to a final agreement, resolving the claims that were brought to the mediation. And that can be done in a memorandum of understanding only, which then the parties' attorneys can translate into a final agreement. Or I can also prepare the final agreement, noting that I'm not representing either party, I'm their mediator. And an attorney working with a client on the side can either draft that final property settlement agreement or final custody agreement, or they can at least review what I've drafted and tell their client, hey, I have some suggestions for revisions. Another way that an attorney can help in mediation is filing the divorce paperwork, because again, I cannot file that on behalf of the parties because I don't represent either one of them. So I can't enter my appearance on either side. So an attorney could just simply file the paperwork for them, and that helps them too. So lots of ways attorneys can be helpful. I don't require the parties to have attorneys. I like to know if they are working with one, though, and who that person is, and if they want me to send the session notes. But other than that, the attorneys generally are, kind of in the background during our mediation process.
I think people might question, isn't that hard? You have the knowledge, you have the attorney, you are a mediator, but it's not uncommon as a real estate agent. Also, we do, at least in Minnesota, we can do certain things, but
Sure.
we have to be very careful that we don't become a lawyer. We have to be very careful that we don't interpret anything, because then we're outside of our scope. So it's not uncommon for people to know stuff, but they can't necessarily act on it in the moment.
100%. Like, I'm like, literally, like, I'm doing it for people that are listening. I'm like taking off, take off one hat and put on the other hat. And I am very conscious of what I would do if I represented either of the parties. And I have that thoughts, going through my head, and I can't suggest it. I mean, even like, I'll run support calculations. If both parties agree, I say, hey, if you guys agree, I can use my family law software and run the support calculations for child support for you. But you guys have to agree that you want me to do that. Every time I'm doing something that is, lawyerly, I'm getting their agreement, I'm putting it in writing that they've agreed. I offer a lot of suggestions of ways to resolve things. And I do take those from being an attorney that represents parties in the family law arena, but I'm never telling them what to do. I will always say, like, here are some options of ways to resolve it. Here are some things I've seen parties do, because while they are supposed to really be driving the conversation and the mediation, and I'm there to facilitate, most parties are looking for some examples or looking for some help. And so, but it's that line, like you said, like, it's really that line of like, I can't say, well, if this was my case, I would do a 60-40 split with no alimony. Like, I can't say that. I can just say, here are some options. If we did a split like this is what the numbers would be. I just have to kind of really leave it very general, and really, like, the phrase that comes to mind is lead them to water. I'm leading them to the water, and they ultimately decide whether they want to drink and come to an agreement, essentially. Mixing some metaphors there.
Excellent metaphors, and thank you for that clarification. And for our audience, that is it for today's episode of Family Law A to Z with DBD. If you'd like to learn more about Elizabeth, Liz, Billies, or the family law team at Dischell, Bartle, Dooley, visit dbdlaw.com for resources and information about divorce, custody, mediation, and other Pennsylvania family law matters. Thanks for listening. Remember to subscribe, leave a review, and share this episode with someone who may find it helpful. Thank you, Liz.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.